Hello everybody out there. Hopefully you're all logged in. Hopefully you can all hear me okay.
I've got 6 participants.
We might just give a few more minutes for everyone to jump on and then we're going to kick some things off. Hopefully you're keeping cool, beating the heat today. Not a very nice day out there. Or it depends, maybe it is for some. So for those that are online, can someone maybe just jump into the chat box? Would appreciate if you could just let us know if you can see our PowerPoint slide and if you can hear us okay, that would be appreciated. Just waiting there. Hello, there we go. All right, hello everybody. Hi Sharon, Joe, Sass, yep, and Elizabeth. Beautiful, and now Sandra. Perfect. All right, so given that we're just a few minutes late, I think we'll start kicking things off. Otherwise, we might run a little bit too late and over time today. So on behalf of KJK, I just wanted to say thank you for being flexible and adaptable and attending this webinar now on Zoom. We were really hoping that we could have the opportunity to discuss this with you in person, but it would appear that COVID and the universe had some other plans. So before we commence, just a few housekeeping things. So we've already ticked off, you can see me, you can hear me, that's great. You've got access to the PowerPoint. So you will have noticed there are no microphones for the attendees today. So any questions that you do have, please shoot them through into the chat box. And we're really happy for this session to still be somewhat interactive. So please feel free to ask these questions as we go. And there will also be an opportunity for you to ask some questions at the end. We've got a bit of a Q&A session for you. We're hoping the session should conclude around 5:15, but we understand if something does come up and you need to leave the session. If this was the case and there was a question that you wanted answered and we haven't covered it off yet, please feel free to jump in and get in touch with us and we'll do our best to answer it for you afterwards. Given that we're having this session now online, we would still like to invite some feedback from you. So after this session, we'll be emailing you something that looks like this. I don't know if you can see that, might be a bit tiny, but this is our feedback form. We'd love some feedback on today's session. We also invite you to provide some more generalised feedback. We were hoping to get just some feedback from you on our performance and how you think we're going. So what we will be doing when we send out these feedback forms, we will be emailing a copy of this. This is the presentation. So you will all get a copy of that into your inbox. Hopefully we'll look at doing that sometime early next week. And one final thing before we kick things off, fingers crossed, we're hoping this session runs smoothly with no technical issues, but you never know. So if something does go awry, please bear with us. All right. Perfect. So most of those that are joining us today are long-standing clients of ours, but we do have a few new faces joining us today. So I thought, well, who are we and what do we do? So not only can KJK Legal provide practical and cost-effective outcomes on our workers' compensation claims, we can help your business to deal with all aspects of work, health and safety law, including injury prevention and legal compliance. We also provide advice and representation on employment relations and are experts in providing the heavy vehicle and trucking industry with advice and representation and defence and prosecution. So we can help support in any of these other ways too. You can just let us know. So we also have 2 new faces that have joined in our team. So that is Susanna and Oliver. Just spin around, say hi, Oliver.
Hey everyone.
Hi, and Susanna. So we're lucky that they've joined us from the other side of the fence, having practiced in plaintiff legal firms. So I'm sure you're going to get to know them well over the coming months. So we're going to cover off a few topics today, obviously quite topical, you can't escape it, COVID-19. We're going to do some discussion on suitable employment under Section 18 and also then the pre-approval of medical expenses and surgery. So I'm going to start off by talking to you a little bit about COVID and some statistical analysis that we've got. So I'm sure by now we're all a little bit too familiar with this image and this one. So 2020 has kind of meant physical distancing, isolation, lockdown, good hygiene, cleaning, you know, all the things, perhaps not the words we would have liked to use to describe this year. And so that recent lockdown shows we're not quite out of the woods yet. So some industry information has been gathered by Safe Work Australia in regards to workers' compensation claims, which has been detailed in their current report. So the data snapshot shows us that there have been 533 workers' compensation claims. And as you can see, there were 253 of those already accepted. I guess we would potentially now expect those number to be higher, given that there's been that second wave in Victoria and those recent outbreaks in New South Wales and then here in SA. So it looks like there's still about 185 of those claims which are now still undetermined or pending. So unsurprisingly, the main reason for lodging a claim was due to contracting COVID. That was with 38% of the claims. And this was closely followed by lodging a claim for the mental health related aspects with 34% of the claims. Also, unsurprisingly, the industry type with the most claims was healthcare and social assistance with 34% of claims. And overall, 184 community and personal service workers lodged the claims. So then when we look at this by jurisdiction, New South Wales had the most claims with 299, then followed by Victoria, Queensland, Tasmania, and then to date, South Australia has only reported those 4 claims. And then this last slide here highlights that more women have lodged claims for COVID and for the mental health related impacts. So as I understand, the claims data will continue to be reported to Safe Work Australia from the relevant state and Commonwealth regulators. And at this stage, there hasn't been any specific claim information has been provided by Return to Work SA or the relevant regulator on the claims lodged here in SA. But if you'd like to review this report in more detail, it can be provided on the Safe Work Australia website. So then prior to today's seminar, we actually had a few people submit some questions to us regarding COVID and implications for workers' comp and COVID and WHS. Questions such as things like, is COVID compensable? A JobKeeper payment included in the calculation of AWE? Is a worker receiving income support entitled to have those JobKeeper payments? Should JobKeeper payments be included for weekly payments? And is COVID-19 a valid excuse for not attending an IME? So we're going to briefly cover off on some of these questions, but feel free, if out of the ones you can see on your screen, I'll just get you to the next one. So there's some of those questions. If you'd like some of those answered, just in the chat box, shoot them through and we can. But then I'll hand off over to Neville and he will start discussing some of these considerations.
Okay. Hello, everybody. I've got a feeling our 4 SA cases may increase over the last couple of days. A few days, maybe one from a pizza bar and perhaps one from a hotel. We'll have to wait and see. But otherwise, I think we're running pretty well as a state in South Australia. And looking at the list of attendees today, I think you as employers would be doing pretty well as well. Although we do have SAPOL on the line, so obviously some frontline workers there that are putting themselves out there and in the hotels. I guess the first question, is COVID compensable? Yeah, of course. No, definitely not, and maybe. So it just depends. Contracting a viral disease is compensable if it arises from work. Out of employment, and employment is a significant contributing cause. That's established, there's no issue there. So what the issue will be, of course, is establishing where and how and from whom an employee claims to have contracted the disease. And that's going to be tricky because at the moment the onus is on them to establish the burden of proof. Now, what would you do if you got a claim? You would investigate it in the normal process. So you may well be assisted, and the worker may well be assisted in this case by contact tracing. So SA Health could do a fair bit of the job for us when it comes to establishing where the the initial contact took place, and that could fast track either an acceptance or rejection of a claim. And there's also, there'll need to be a bit of a common sense approach as well. I think if we have claims from healthcare workers or police, the odds are that it may just be as simple as accepting the claim and hoping it's only a couple of weeks off work and there's no long-term effects. That's one thing we don't know really too much about yet, is what will be the long-term impacts of COVID. Most people appear to recover reasonably well, unless they already have a pre-existing condition. Again, looking at our list of attendees, I would hope and think that most, if not all, would not have had to worry about JobKeeper. If that's not the case, you can let us know after, so we can have a general chat. But if so, or if in the future we have our second or third wave or a second pandemic, there may well be more JobKeeper. It does end in March, but as you know, it's been running for quite some time now. So if a worker is receiving weekly payments, are they also entitled to JobKeeper? The simple answer is if they're totally incapacitated, no. They're off work, they're just receiving their weekly payments. If they were at work performing modified duties and perhaps getting some top-up component, and that had to be withdrawn because of COVID, and they then became entitled to JobKeeper, then there would be an entitlement. So that's fine, as long as they're performing work in reward for some form of wage. That would then lead into the question there about, are JobKeeper payments included as earnings for weekly payments? And the answer is yes. It's set up such that a worker would not gain the benefit of having weekly payments and then being topped up, having earnings and then being topped up by weekly payments and then getting JobKeeper on top of that. It doesn't work that way. So the JobKeeper payment will form the equation of what are the earnings for that purpose only. So if a worker is already incapacitated and they're entitled to JobKeeper, you would then add up their wage component, the JobKeeper component, and then if there's any difference, you top them up. Otherwise, you wouldn't have to. More interesting, I guess, will be the case of workers that have subsequent injuries to having been on JobKeeper. And as you'd be all aware, that we then look at the previous 12 months' earnings to establish what the average weekly earnings rate would be. This may lead to some issues and concerns from workers if they have been on JobKeeper and that's all they were receiving because their employer was particularly impacted by the shutdowns, such that perhaps if their normal wage was $1,500 a week and they dropped to $750 a week for a period of time. And then when we just do our normal calculations, we'll say, okay, you only are entitled to have any JobKeeper payments included if you were exchanging those payments for some form of skill and labour. And if you're just being topped up to the JobKeeper rate and sitting at home doing nothing, then potentially that don't count at all. And likewise, they may have been just topped up to the $750 and doing some work, but normally earning more than that. So it does have the implication that overall average weekly earnings could actually be lower than normal for reasons of no fault of the worker, of course, and of no fault of the employer. So it'd be interesting if there are disputes raised as to how the tribunal will approach this. I think it may be more interesting if a worker has already returned to their full hours at the time of the subsequent injury, such that the JobKeeper period was only a fairly brief one. We'll have to wait and see what happens next year sometime, if or when there is a challenge to a determination may or may not lead to a dispute. There's a couple of questions on the slide dealing with registered employers. I don't think we really have any registered employers on the list, so I won't delve into those. But again, if anyone has a question, we can deal with those after question time. Are there any Section 18 implications if you can't provide work due to COVID? I would have thought the simple answer is it's unlikely, given it's something totally out of your control. And if you genuinely cannot provide suitable employment and it's not reasonably practicable to do so, that a return to work is not going to criticise you as an employer for not providing duties to a worker. The usual obligations under Section 18 will apply, but as we know, subsection B provides us with an out if it's not reasonably practicable. What do we do if a worker, and this is probably more valid to what happened earlier in the year, sort of March through to about July or so, when everyone was in panic mode and really didn't know what was going on. Doctors were, had to close their surgeries if it wasn't essential, and everything was thrown into disarray. And when they gradually opened up, you may or may not have had some workers that decided that they thought it was too dangerous to head outside, let alone go to a doctor's surgery for an IME. What would you do if they refused to go? Now, they probably have less of an argument not to go, but even so, if they still had some opposition to attending an IME, you would really need to ask for them to have a valid reason, such as they've got some compromised immune system or some respiratory issues. I think just the basic, fear of not wanting to go and see a doctor is not good enough, unless there's a valid health reason behind that. Again, it's going to be a case-by-case assessment, and we do have the telehealth facilities available still, not that they're ideal, so that's obviously an option, but in my preference, I think it's better that workers go and see the doctors these days, and most of the doctors are now willing, have opened up and they're willing to see workers in person. Moving on to the next slide, we sort of delve here into a little bit of crossover between work health safety and workers' comp. Just sticking on the workers' comp for the time being, can you lodge a claim for compensation if you're working from home and you contract COVID-19 from the person residing with you? Interesting question, and one that well, again, has that yes, no, maybe type answer. It really depends. Yes, you can, if you're working from home, and obviously your home then becomes your workplace, and you contract COVID from someone in your household, then potentially, yes, it is compensable. However, it's going to be difficult to discern where and when the actual contraction took place, because even though they're at home at work, they're also at home. And when does work start and when does work finish? Where is work? Is it contained to a particular room or rooms in the house, such that once they leave that area, they're no longer at work? So quite a myriad of questions could arise from that, and there might be the perimeter type argument. Well, I was close enough to work, so it must be work, or they still have to be working. So did they catch it when they were having a coffee and after work, or who knows? So it's going to be interesting if those sort of claims come through. Luckily, we don't have the amount of claims to be too concerned about, but perhaps in Victoria, this might be more of a hot issue. So leading from that is, can you lodge a claim if you're injured while you're working from home? Now, this is more about an injury rather than COVID or a remote location. Then yes, you can. There's plenty of case law to say that as long as you have a connection to your employment and you're in the course of your employment and you suffer an injury, the location itself is not particularly pertinent. Hence, I think when we now cross over into the work health safety issues, that is the importance of trying to establish where the workplace is at home. Now, I'm not suggesting that we'll go out to our employees' homes and do a full risk assessment and set up SWMs and all the work health safety tick boxes. But I think for employers where you are now encouraging employees not to come back to work and perhaps to stay in their homes to work, where work from home is actually suitable, and it's becoming more of a permanent arrangement, really there should be some form of risk assessment, and it can be self-assessment, but you as the employer would be probably recommended to just have a checklist such that the employee can do a self-assessment at home and make sure that they do have an appropriate workplace. I think you really need to set where the work boundaries are, what is work, what is domestic environment, such that the worker sitting on the couch at 11 p.m. at night, reportedly doing some work while watching TV, and the cat jumps on their lap and spills hot coffee all over them and they get scolded. Is that going to be a work-related injury or not?
I do that all the time. What are you on about?
I know you do it all the time, Francis. We all do it all the time. So,
I've always thought I'm working.
I'm trying to be sensible.
True.
So there's a few little work health safety considerations I'll get to in a sec. Alternatively, what would we do if an employee says to you, comes into work and says, look, I've been told to self-isolate. I can't come to work. The doctor or the authorities have said that I have to stay home. Are they entitled to workers' comp? Well, no, because we don't know where they've got the potential infection from. We don't even know if they've got it yet. Are they entitled to sick leave? No, because they're not sick. So are they entitled to some other form of leave? Yes, they can take annual leave, they can take long service leave, they can take leave without pay. And there are also a number of awards now that have specific COVID pandemic provisions in them. For example, some awards such as the Aged Care Award Health Services have paid pandemic leave up to 2 weeks at a time on each occasion. Schedule X of most of modern awards now provides for unpaid pandemic leave as well, or the option to take annual leave at half pay so that you can still have some income but not necessarily use up all of your leave at once. Those provisions do have a sunset clause as at 29 March next year, and I imagine, like everything with COVID, that could be a moving feast depending on what's happened in the interim. Some awards also allow for more flexible working arrangements, such as the Clerks Award, where ordinary hours are now, for example, 6 a.m. to 10 p.m, and you can work on Saturdays as well without overtime being an issue. But again, as employers, we need to keep track of what the employees are doing, what hours they're working, and ensuring that they're safe at home. Finally, I think I just want to touch a bit more on the work health safety issues at home, given that so many people are now working from home. So I think it's important to ensure that your employees do have an ergonomic workstation to work at, and that there is some policy and procedure in place that effectively requires them to perform their work in a designated area such that the entire workplace isn't the entire home and the front yard and the backyard and the pool and whatever else may be at the house, in order to essentially just mitigate our risks. Any hazards should be identified, and this again I think would come back more to the self-managed risk assessment, but provided by the employer, such that the worker provides you with a checklist and says, yes, look, I've ticked everything off. At least they can't then turn around and say, well, I didn't know that PowerPoint was dodgy and before I got electrocuted. So, hence hazard identification. Communication is a big thing too. Mental health, we can't ignore that. There have been a lot of mental health issues arise from isolation. I know I had them just the other day when I had to stay inside and couldn't go out for a day. And let alone people that are working at home all the time, they're not having that interaction with their co-workers as much. And if they are, it's by something like this, which is really second rate compared to actually having an in-person meeting or seminar. So I think as employers, we need to figure out ways to create that sense of community and socialisation with our workers. Have a contact person if somebody is in need of help, or they're injured, or they're suffering some sort of mental issues. Someone that they can easily contact to have a chat with or report to. You still have to have your incident reports, so your general policies and procedures still have to be in place. They may need to be adapted now, but if you didn't have work from home before, and you do now, you might want to have a review of your policies just to make sure that you're covering off on now the home situations. And again, just ensure that, it's very tempting to, as Tracy said, you can sit and do work at all hours of the day and end up doing a lot more time than you normally would because there's nothing else to do during sort of semi-lockdown periods we had. But that's not necessarily good for your employees, and everybody needs to have their free time. So having at least some sort of policy in place about that. Otherwise, unless there's any questions right now, and we will have a bit of an open session after, I'll hand over to Mark to talk about Section 18.
Good afternoon, everyone. Welcome along. I'm a director here at KJK Legal, for those of you who don't know me, and for those of you who have not heard me speak about Section 18 before, and those lucky enough to be working from home and don't want to hear my introduction, go and get yourself a G&T and come back in about 5 minutes and we'll kick off. But for the rest of you who maybe some of this is new or you're really looking for a refresher, then please stay online and we'll get into it. So Section 18 obviously has been around as part of the Return to Work Act for a number of years now. It was implemented in 2015 along with the rest of the Act as a general overhaul of the legislation. It provides for a ramped up level of obligation on employers in particular, and the General Act of itself ramps up obligations for workers and employers in relation to the whole issue of return to work, which is why they call it the Return to Work Act. So that's, in a sense, is fairly obvious. But it's created this whole concept and a jurisdiction around a worker's ability to request and then effectively ask the tribunal to intervene in the opportunity to be provided with suitable employment by their employer. Now, while we've obviously had a number of cases in this area over the last 5 years, I think it's fair to say that it really hasn't led to the plethora of litigation that we first thought it might. It was ultimately, I think, something that was more scary than the reality, and that's in a sense proven to be the case. And I think if you look at the statistics, while there's been a reasonable degree of initial litigation in this area, there's been very few cases run to judgment. And that's probably in a sense because of a couple of factors. Each case is dependent on its own facts. So there's always that question that you never get a slam dunk in any sense when you litigate one of these matters, because you never know what you're going to get when you throw all of your individual facts and circumstances of your case up before a judge. And also consistent with the Return to Work Act of itself, that you have that opportunity, well, not an opportunity, you're beaten over the head to literally conciliate outcomes, both in relation to general disputes at the tribunal and under Section 18. The judges are relatively interventionist in this area, and because it's more of a direct employer-employee situation, it does lend itself to getting more outcomes than you would ordinarily think, because you don't have that problem with particularly registered employers. You're in a litigation environment where the claims agent really doesn't have a role to play. And if you're the self-insurer, well, you're it anyway. You're the employer and you've got control over the outcome. So a quick recap, if we go back to first principles of Section 18, and the whole thing starts with incapacity as the key to the whole thing. I think we've jumped one screen ahead. There we go. Beautiful. I thought I was talking quickly, but not quickly enough. So incapacity is the linchpin of this provision. If you're not incapacitated for work, then the section really doesn't have a role to play. And when we talk about incapacity for work, we of course talk about work-related incapacity for work. I know there's been a couple of cases where, and I've been involved in a few where workers' lawyers have thrown up the fact, well, my client was incapacitated for work a number of years ago, and now you've terminated them. Oh, we want some Section 18 relief. Please provide us with suitable employment. While there's been no decided cases on the area, that argument really hasn't found favour with the judges. So I think we've got to say, at the end of the day, incapacity is the starting point for all this. Let's assume you've got that incapacity for work. The section itself provides 5 upfront defences, so to speak. Some of them require a good deal of evidence and literally a trial. Some of them may be more receptive to being the subject of a quick literal strikeout application. And we'll go through those as I look at the section. So in a sense, obviously, an employer doesn't have to provide suitable employment if it's not reasonably practicable to provide it. Nor do they have to provide suitable employment if a worker, having had an injury, has failed to report it, then resigns, goes away and comes back later on and says, oh, please provide me with suitable employment. It's a defence to a request and subsequent application in this regard if they've already left the employment. Or if they've terminated their employment, and I talk in that sense of the worker taking the decision to terminate their employment after their incapacity has commenced, and then turning around at some later stage and saying, oh, look, I've had second thoughts, sorry, please provide me with suitable employment. Unless I think the employment termination was arguably a constructive dismissal, then ultimately, again, that's a defence to the claim. Sorry, you took it upon yourself to resign and now you've left. Things have moved on. We don't have to provide you with suitable employment. More particularly in the case of registered employers or occasionally with self-insured employers where you've agreed new or alternative employment options as part of the return to work process that might involve being placed at a different employer, and where the rehab and return to work direction takes you in that way. You might be because you're a very small employer with limited ability to provide alternative duties, and therefore the claims agent rolls in and says, okay, well, let's look at trying to find you something on the broader employment market because we simply can't find you anything to do with your pre-injury employer. Then again, that is a notional defence. And look, if the worker has what they call otherwise return to work to their pre-injury employment, then obviously that in a sense takes away the ability to ask for something else, because the whole tenor of the Act is, of course, to return you to your settled and established employment, which in a pre-injury sense means it would be either your pre-employment or pre-injury job, or at least a substantive role of that nature. Now, Section 18 as a process kickstarts obviously with a worker making a request to be provided with suitable employment. that is not so much that they bring an application at the tribunal. That's a secondary part of the process. They've got to make a request to be provided with suitable employment. There's no hard and fast rules about that. We'll talk about that in a little while. But effectively, the employer needs to be on notice that the worker is looking to be provided with some form of suitable employment. Once you've considered that you have been provided with an application in this regard, then the employer has the 1 month in which to respond to an application before the worker can then seek the intervention or relief from the Employment Tribunal. They can't bring an application at the tribunal within that 1 month period, even if the employer says right from the get-go, nick off, not interested, go away. The tribunal then, of course, having considered the matter, taken evidence, the matter might go to trial, will, if they find it is not unreasonable for the employer to provide suitable employment, will make an order in that effect, unless, as a sort of secondary fallback position, they consider in the circumstances of the individual case, there are good reasons why they shouldn't order that suitable employment. So in a sense, the worker might be able to perform some sort of employment with the employer, but there are a multitude of other reasons why in this case that would not be the appropriate order to make. And to tie all this off, when the Employment Tribunal does make an order in this area that the employer do provide the worker with suitable employment, if the employer does not do so, then they are open to being penalised by way of a pseudo form of weekly payments that is intended to equate with the amount the worker could have earned if they were provided with that suitable employment. And that has 2 ramifications. It's arguable, in fact, if not clear, that that can apply after the 104-week weekly payment entitlement period otherwise ends. And I don't think it's necessarily an 80% factor either. If you're fit for a form of employment that attracts a wage, then I'm expecting the tribunal to say, well, the penalty to the employer in the event they don't provide that employment is to pay the equivalent wage. Now, for those who, of course, have heard us talk about this area before, Walmsley's case still remains the primary decision in this area, both as to the processes around Section 18, the onuses that apply under Section 18, who's got the evidentiary onus of proof, the criteria by which the tribunal will look at and make an assessment in each case whether the employer is required to provide suitable employment. So if I take Walmsley's case as the starting point and a number of them that follow from there, these are, we just go back. So again, there we go, sorry, having fun with our slides. So we're all good now. So you can apply under Section 18 of the Act for relief as an injured worker, even if you've been terminated from employment and whether or not you've pursued an unfair dismissal claim. Interestingly, with the serious and willful misconduct that might lead to the termination of employee, that's come up in the tribunal as a question. Well, okay, we've sacked someone guilty of serious and willful misconduct. They've come back and asked for Section 18 relief. They didn't go to the Fair Work Commission. Do we have to effectively prove all over again the fact that there's serious and willful misconduct? The Employment Tribunal has basically said, no, we will ordinarily let the employer on the documents put forward the basis for why they might have terminated the worker for serious and willful misconduct, or in the serious or willful misconduct as the industrial forum provides as the test. And it then is to the worker to be able to, or to show evidence that would contradict that outcome and show that it was not the appropriate outcome in the first place. Outcomes in the Fair Work Commission don't necessarily affect what a worker may or may not bring forward as a Section 18 claim. And we're quite familiar, of course, with situations where a worker might bring an unfair dismissal claim, settles it up for some damages that might reflect the loss of income for a period. Even though they might have consent orders in that jurisdiction, it doesn't necessarily stop them coming back again. I've said here, and if we have a look at the slide, being a bad egg doesn't mean you can't press your claim. A couple of the cases have dealt with the issue. It came up in Walmsley's case and one or two others that followed, that the sort of person who's got a poor attendance record, poor disciplinary record, has antagonised half of the workforce, is the employer required to take back the bad egg? And the tribunal has consistently said, yeah, well, they might be a bad egg, but that isn't the entire answer to the question in most cases. Perhaps the exception to the rule might be some strong and persuasive evidence that 99.9% of the workforce would walk out the door, quit, resign, or not come to work if Fred Bloggs was ordered to be able to come back into the workplace. But short of that, no, just being a bad egg, square peg and round hole, doesn't disentitle you to pursue an action in this area. I've mentioned it because I was in the mood when I wrote all this up, quoting people like Bill Clinton. It is the economy stupid, but only sometimes. Effectively, when you have economic considerations that apply in your workplace, can we afford to take this person back? That is an important consideration. It's not the only consideration. And as I'm going to emphasise with a lot of these particular issues, it also reflects, as I say in the next dot point, the bigger the employer, the bigger the risk in this area. A small employer who's running on a bare bones profit margin, who can't, and has an employee they're required to take back who might only be 20, 30, 40% productive in their real job, but is expecting to be paid the full wage for the role, that might tip that employer over into bankruptcy because they simply can't afford to pay that employee to be unproductive. It's also a reflection of why you see in this area that generally the only matters that get to litigation are involving medium to large employers, because quite often with the very small employers, these sort of economic considerations are a really big factor. And also, of course, workplace considerations and the square peg in the round hole is going to be a more significant factor when it's coming to the application made by a worker who wants to come back into a 2 or 3 person automotive workshop, as opposed to someone coming back in onto the factory floor at one of our bigger state employers. Past employments is an indicator of future opportunities. If we channel a financial concept, it does suggest that what you've been able to do in the past, your ability to turn your hand to other roles, how many roles you performed within that employment environment before your injury, is usually a good indicator of what might happen in the future, what you can turn your hand into the future, your adaptability as an employee. So as a large employer who's got a multi-skilled workplace where they shift people around within different roles all the time, is arguably going to find it harder to resist an application by someone in that regard, as opposed to someone who has only ever been a ditch digger and is no longer able to work as a ditch digger and is illiterate, etc. So again, it comes back to that's an individually based factor, but it also reflects upon the workplace. The bigger you are, the bigger the risk, as I've said. I had an example in the last day or two where someone lodged a Section 18 request at this stage, where they literally said, oh, well, I've performed alternative duties for you on occasion in the past in various roles. You're not providing me with employment at the moment, and I'd like you to provide me with suitable employment. Well, what they haven't identified is a role or a mix of roles that they might be fit to perform. So I've said to the client in that case, we can't deal with this in a vacuum. We need some understanding of what employment or roles within employment that you are asserting you have the capacity to perform. So the early cases talked about needing to identify a specific job, but as the Pahara case, we'll talk about that in a minute, is identified, you can actually, in a sense, grab bag a number of roles within the workplace and nominate them as suitable employment. Again, it'll come back to the facts and circumstances of each case. That said, it's not a case of being unreal about what you're talking about. If you have always worked on the factory floor and you can no longer work on the factory floor, but you've got ambitions to be the manager of the plant, well, that's terrific, but it's not necessarily something an employer is going to be required to respond to when you make a suitable employment application. I've then said, stick to the program. You can't make things up as you go. That's a comment about workers and what they bring forward as applications. The tribunal has said, if you nominate a certain type of employment, whatever it might be, you don't get the opportunity during that application to then drag in all sorts of other types of employment that you suddenly realise you might be able to perform. The tribunal has, in a sense, tried to put a cap on the jurisdiction by saying, if you nominate something, we run with that and we deal with that. You don't get to drag in everything else that you might think might be a good idea further down the track. Particularly in government circumstances and in the government field, and we've seen the tribunal talk about this with education matters, a Section 18 application is not a basis to get a leg up over other employees. So in other words, excuse me, it's not a way to circumvent the promotions process, not a way to circumvent jumping from one role to another where there might be a competitive employment process otherwise. So no, the tribunal won't give you an inside running just because you nominate something. You've literally still got to, in that sort of situation, be qualified for the job by way of experience or longevity of employment or whatever the other criteria are, or pass an interviewed panel, whatever it might be. You don't get to circumvent things. That said, the Employment Tribunal has said in one case, there's nothing to stop the judges in this area, in a sense, stepping into the employment field and the employment contract and literally saying to the parties, okay, we've heard your evidence about what the worker can and cannot perform and in what circumstances and in what environment. And in one case, they effectively decided, well, we're going to order the employer to provide a certain type of employment for a certain number of hours and days per week and at a certain location. So and that had an impact, in a sense, on the employment contract. And finally, and this is where we're going to deal a little more deeply today, work health and safety issues. We've had a number of cases, and starting back with Walmsley's case, and if you remember Walmsley's case, was the situation where the workers supervisor came to his managers one day and said, look, I don't think we can keep providing Mr. Walmsley with employment. His last aggravation was a result of him bending over to pick up a pencil and his back went on him. How can we provide him with a safe workplace? And Mr. Pahara's case, which we'll talk about, raised the same issue. Conversely, other cases have dealt with the issue and found in favour, effectively, of the employer by saying, yes, there are circumstances in which work health and safety considerations will be a significant factor when it comes to how we might assess whether we require an employer to provide suitable employment in the particular case. So if we talk now about Pahara's case, and we did talk about this one previously in our last, or one of our earlier seminars, I'm talking about it again today because it went on appeal. For those not familiar with the case, Mr. Pahara was a stevedore. He sustained a back injury in about 1994. He was able to return to work. He had a spinal fusion in 2015. But because of the passage of time and then he actually returned to work, his weekly payments were ceased in 2016. In 2017, again, because of the concern that the employer had about whether they could provide him with a suitably safe workplace, meet their work health and safety obligations, they withdrew duties from him, literally stood him down. The worker, of course, then brought an application requesting suitable employment. He identified a number of roles within the workplace that he said he could perform. Most of them had elements of his normal duties, but some of the elements of his normal duties he could not perform, and indeed he had suffered aggravations as a consequence previously. The trial judge looked into the matter and particularly looked at him, what he had done in the past, what he had been doing post his injury date, what his employer was able to provide, It looked at the makeup of the workplace, what everyone else there did, and ultimately decided, yep, as an employer, we understand there might be some work health and safety considerations that you have, and you might have some concerns about this worker aggravating, but nonetheless, and even though in this particular case, Mr. Bahara was one of those square pegs in a round hole, they still said, no, you can provide him with suitable employment, and we make that order. The employer took it on appeal, and unfortunately for them, got a knockback. No, said the full bench of the tribunal. There are good reasons why this worker has a capacity to return to work with you. Yes, there are considerations that might weigh against it, but with all of these cases, they're a balancing exercise, and that's what the tribunal undertook in this case. The first point they took on appeal as the employer was to say, well, you know, bad employment record, you know, particularly with discipline and attendance, you know, why do we need to take him back? The tribunal said, yeah, relevant consideration, but it's that balancing exercise. So they said it's of itself not really going to be the sort of thing that stops us going further into the matter and giving consideration as to whether you should be providing suitable employment here. The employer then said, well, look, effectively what the worker requested and what the trial judge found was that this worker could throw up a bunch of different roles, and, you know, we had to consider finding him within suitable employment in that regard. They said, that's too wide an inquiry. Surely he should be just nominating a job. What they said in that case was, well, that might, and the full bench of the tribunal said, yeah, well and good in the appropriate circumstances, but Mr. Employer or Miss Employer or non-specific, non-sexual, generic employer, you're a big employer. You have a lot of roles available. This worker's performed a lot of those roles. He performs them even on a day-to-day basis. He can be working in that area in the morning, that area in the afternoon. Your workforce is almost like that. The workforce is heavily weighted towards part-timers and casual people. And on any given day, they can be brought into the workplace and be working in a completely different area than they were the day before. So to that extent, in the appropriate circumstances, a worker can say, well, I'm going to literally, in a sense, cherry pick the odd role and cobble them all together, as long as they're suitable for me by way of my skills, previous experience, etc. So the employer didn't get by on that one. Now, that's going to be probably a situation many large employers are going to confront, particularly where the workforce performs a multitude of roles. So always be mindful of that. Again, the employer raised the work health and safety card. This fellow had had exacerbations in what were fairly innocuous circumstances. So again, the argument, how can we keep the workplace safe from someone who, you know, injures themselves bending over to tie up their shoelace or whatever? The tribunal said, okay, we understand that, and that's an important consideration in the right case, but there are a number of answers to that. One is, we can't all be wrapped in cotton wool when we're at work, and plenty of us get injured when we haven't got a pre-existing problem. So that's not an answer of itself. Secondly, they said, as it is, there's always an element of risk in any job. The question is, and this is where they threw it back to the employer, what are you doing about the risks that are identified in the case and dealing with them? Because you have a primary obligation as employer to provide a safe workplace. So in this case, for example, the worker he had a bad back, obviously. One of the jobs involved driving around on a forklift. The work site itself had apparently plenty of potholes in it as you drove around. And as we all know, forklifts are not the most well-sprung, comfortable vehicles in which to go off-road driving, let alone drive over potholes in workplaces. So what they said to the employers was, well, yeah, that might be the case, and he could aggravate his back if he was to run over a pothole while driving the forklift. But why are you allowing the potholes in the first place? Haven't you got an enduring obligation to go back and address your own work health and safety obligations? Because that's where it all starts, and literally, in a sense, where it all ends. So they said in that case, you were able to control the risks in the workplace. Not all other employers can. And that's a contrast to Harrington's case, which we've talked about before and which is a really good counterpoint to Bahara's case. Because in Harrington's case, this was an employee in a nursing home, again, a work injury, which meant that there were instances where if she was exposed to certain circumstances, she was quite at risk of injury. And of course, in nursing homes and residential care environments, you have a heightened need to be able to provide assistance to people that can't always be achieved by lifting equipment and safe lifting circumstances. For example, and this was the case in Harrington's matter, there is the unexpected. The person who, while you're conducting a two-person transfer or a one-person transfer because they are actually certified as being capable of that, they're semi-ambulant, suddenly and unexpectedly drops their knees and you take the weight of that individual. You might be in compliance with the care plan, but you run up against an unexpected circumstance in the workplace, which takes it out of that ability to nicely control everything you do about your work. So in Ms. Harrington's case, what they effectively said was, at the end of the day, it was a work health and safety risk to the employer, the worker and fellow employees if this employee was to be able to come back to work and perform duties as an enrolled nurse. In a perfect day, she could get by without any risk whatsoever, but there were significant enough uncontrollable risks that meant it was inappropriate for her to be, inappropriate for the employer to be required to take her back into the workplace. So work health and safety has a role to play, but again, we emphasise facts of every individual case will dictate to what extent that's literally a get out of jail card or it's something that you're going to have to deal with and make allowances for in the ordinary course. Now, full bench in Bahara's case, 3 of the judges sat on the matter. They all agreed on the primary outcome, that is, yes, it was feasible for this employer to provide suitable employment to the worker and made the order concerned. One of the judges, Deputy President Lischke, went a little bit further and threw up a couple of, well, let's call them discussion points, signposts for the future. Some may say it's the velvet glove the sledgehammer in the velvet glove. We'll wait and see. And he also picked up on an issue that Deputy President Farrell had also dealt with in a prior case, and that is, firstly, where you are dealing with this area of the Act, recovery and return to work plans can be a vehicle by which you facilitate the assistance of the worker back into the workplace and providing them with suitable employment. It's not a time-limited provision. So in essence, the worker in these cases can say, as part of facilitating my return to work, and I'm past 104 weeks, 2 things. 1, your suitable employment obligation continues, and 2, I want a recovery and return to work plan that helps facilitate that process. And DP Lischke said, yep, that's fine. Rehab or recovery and return to work plans, as we call them these days, do continue past the 104 weeks. He was the one in particular as a judge who really delved into the work health and safety aspect, and literally so that in a sense that the employer wants to run a WHS argument as a defence to a Section 18 application, he has said, you need to do a lot more legwork before I'm going to listen to you because you have the primary obligation. So don't use it as a simple excuse. Be prepared to come with all of your evidence as to why, in this case, work health and safety is a significant factor. And I emphasise, I think, again, that whole notion of the uncontrollable aspect of the work as being the important evidentiary issue you've got to deal with. And finally, he threw in for good measure the Disability Discrimination Act. So in the federal legislative sphere, of course, employers, workplaces cannot discriminate against those with a disability. The expectation is always on employers in this field to make reasonable accommodation to enable injured workers or disabled workers, putting it out of a workers' comp context, need to make reasonable accommodations for the worker to be able to return to work. Now, there's in a sense, a defence in that regard if they obviously can't perform the inherent requirements of the role. And I might give the example of someone who says, well, I can come back in and continue my employment as a teacher, but look, my doctor says I really can't teach kids. Okay, we might have a little bit of a difficulty there. It is not a hard and fast, never can get out of an obligation type scenario, but be mindful. Disability discrimination has been an issue floating around behind this provision and behind this Act and behind the 104 cut-off point for quite a long period of time. Now, just a couple of quick points that come out of Pahara's case. The other one was obviously, depending on the size of you as an employer, yes, you can be expected to cobble together a range of duties. And of course, Return to Work SA love quoting some old Supreme Court cases from many years ago. You don't have to provide them with a real job. You have to provide them with a role, or we expect you to literally make up a job. Now, of course, again, it comes back to size of employer and all sorts of other factors as to whether you can effectively carry someone performing a mishmash of duties in the circumstances you confront yourself as an employer. So dealing with that one, we can then move on finally to McCormack's case and the problem with groups. So this, for anyone who's a self-insurer who is part of, and of course famously WorkCover back in the day when they brought in the new one-in all-in provisions of the legislation and effectively tried to deem a self-insured employer as a group and couldn't really prove how they ever did so, have seemingly cured that problem under the new legislation and the Return to Work Act, and have created a system effectively to statutorily impose the one-in all-in rule on self-insurers. So if you bring in a new member to your group, you literally have no way you can resist not having them part of a self-insurance licence. And that then creates an issue that came up in McCormack's case, because the deemed group self-insurer, who at the time, under the broad ASC, Submarine Corporation umbrella, had 3 related bodies corporate within it. Mr. McCormack was employed by one of them during the course of his employment, with which he sustained an injury. As time passed, he was, in a sense, able to return to work for a while, but then effectively, I think from memory, was made redundant. He brought an application at a subsequent time to that against what was described as his pre-injury employing entity, or a particular body corporate within the broader ASC umbrella. Interestingly, by the time he did so, that part of ASC had been sold off to BEA. He then brought applications against the 2 residual members of the body corporate under the ASC umbrella. So all 3 were involved in the litigation. And the issue came up, well, who is my employer? And if you remember that Dr. Seuss cartoon, who is my mother? Where is my mother? which ASC entity is my mother? So the matter proceeded, and ultimately what was fair, and the case revolved in a sense around whether Section 129 of the registration provision effectively set the scene for everything to do with that self-insurer group as far as the Act was concerned, or whether it was just a registration provision. Because, of course, when you go back to Section 18, it talks about the pre-injury employer. Well, who is my pre-injury employer? Who is my mother? So ultimately what they found in this particular case is that Section 129 set the scene, Section 18 came in underneath that, and under that general umbrella of a registered and self-insured group, that meant anyone who at the time of the Section 18 application was a member of the group, that is a related body corporate within that concept, the primary responsibility lay across the group, excluding, of course, the actual pre-injury employer, because they were out now as a related body corporate within the BEA group. So that's how that ended up happening. That, and I know a couple of you in recent times have brought in new elements to your overall group, new related bodies corporate. So be mindful that it is the employer at the time the application is made, the broader employer, who has the baseline responsibility. What they did recognise in McCormack's case, of course, is if within a group you as an employee have specialised skills and aptitude for different roles, and some other members of the group literally operate in an area of industry that has nothing to do with it, or might be, for example, the administrative clerical side of the business as a group, then you're not necessarily going to find that employer thrusted with the same or imposed upon them the same obligation. It will go back to other members of the group. But the answer is, in a sense, it's a group issue, which comes to my final point when you look at it from the point of view of not necessarily groups of self-insurers, but effectively, say, the Crown, the state government, the departments of A, B, C, D and E and its related statutory instrumentalities. Which worker is going to be the first to say, well, I can no longer work as a teacher, albeit I'm employed with the Department for Education, but gee, I'd like to drive trams. Albeit, no, perhaps that's not such an accurate one anymore. I want to be a train driver. Sorry, bad choice. But literally, can I jump from literally one government instrumentality to another under this provision? Now, historically, the tribunal has said, in not quite this circumstance, but no, look, if you're employed with the Department for X, then that's where the primary obligations all fall back upon under the legislation. Now, whether by analogy they'll use the Section 129 principle to say to a government department, well, actually, you need to look broader because this employee has indicated they're prepared to undertake suitable employment with another department altogether. Whether the tribunal will give that any credence is an open question. My gut feeling is no, because for many years they have, as I said, tended to try to compartmentalise employer departments, government instrumentalities in their own areas. It goes back to a case of Judge McCusker probably 20 years ago, who spoke about a worker who was trying to impose upon government to rehab and return to work, create rehab and return to work plans that would facilitate their employment with another department altogether. And Judge McCusker in the case said, well, I don't think we should be imposing that extent of an obligation on a department, given most government departments are so large anyway, they have plenty of facility to provide employment or assist in the rehab path in any event. So that was not the primary basis for his decision back then, but there's never been any judges who've really said anything different to that ever since. So I think if you're a government employer, you might breathe a little more easily than if you're a group self-insurer. But again, it's not to say that someone at some point in time is not going to run the argument. And when they do, we'll all be the wiser. So with that, I'm happy to, if there are any questions. If not, I will hand over to Tracy. So thank you for your attention. Tracy is now going to deal with that never-ending vexed question, medical expenses and what we do about them. So thanks for listening in.
I need a chair though. Will you give me that one?
I'll give you that one.
Hi everyone. Hopefully there are people out there. I wasn't involved in the practice for this, so this is all a bit weird for me. So hopefully we'll work through the technology. For those who have been to some of our seminars in the past, and that's probably last year sometime, given what we've all been through this year so far, I did run a session on this particular topic at one of our other seminars. So this is kind of like basically an update because we've had quite a few more cases on some of the issues that we canvassed last time. But for those of you who sat through it all last time, probably, as Mark said, good time to have a bathroom break or hopefully top up that gin and tonic that I'm hoping you might all be sipping on this very hot summer afternoon. If not, we're going to, canvass some of the same old stuff, but we're going to update some new stuff that hopefully makes it all a little bit more understandable. So here we go. So the first thing we're going to talk about obviously is pre-approval of medical expenses and services under section 3317. And as we know, in the Act, we have a couple of provisions that look at this issue, and there's been a bit of confusion in the past about, you know, which section applied to what, but I think we've probably gotten to a point where we really should know what section we're talking about. So section 3317 allows a worker to seek pre-approval of medical expenses or services. That could be any type of services under section 33, not just surgery. And generally, in my view, workers are going to be trying to seek that sort of approval in advance if they're not certain as to whether or not the cost would be met, or it's a very expensive service, or there's some controversy about whether it's needed. So they have the ability to seek that pre-approval, and often it is pre-approval of surgery, but that's not the only thing that can be sought in advance. If a worker is pursuing an application under section 3317, they have to comply with section 3318 and regulation 22.2. And that regulation sets out a whole heap of things that they're meant to provide, and that actually go one more. Hang on, sorry. No, sorry, go back. Sorry, I'm not great with slides. I never have been. So there's a whole heap of evidence that they're meant to provide in support of that application. I'm not going to canvass that in any detail because I'm sure you're all familiar with it. If you get that application, you're required to make a decision within 1 month. But having said that, it is possible to defer an application, particularly if it is an application, for example, for surgery, where you want to maybe get your own medical information and arrange an independent medical examination, or you want clarity about the services being sought. And in that case, you can defer the application and obtain that further information before you make a decision. If you are going to defer that application, you should notify the worker. Otherwise, no doubt you'll get an application for expedited decision because you haven't responded within the 1 month time frame. I still see a lot of the old style applications where the orthopaedic surgeon or the neurosurgeon's secretary sends you the pre-approval direct with nothing else, just, you know, Dr. So-and-so wants to do a spinal fusion. Technically, that's not correct. But, you know, I have a number of clients who probably don't fuss too much, because if you go back and say to the worker, well, you need to provide all this information, potentially it just ends up them seeking legal advice, and that can create its own difficulties. But technically, it's not the correct way of doing it anymore. But I do know a number of clients who still allow that to happen, and they just do the inquiries themselves in order to make the decision on the application. So in terms of an application under section 3317, one of the issues that we may have talked about last time was whether or not that actually extended out the entitlement period for medical expenses. Because of course the section 3317 application is technically meant to be brought within the normal entitlement period. And in the case of Giammios, the issue was whether a worker, having made an application, could in fact get services that post-dated the end of the 12-month entitlement period. Pretty much all the way along, the workers lost on that issue, and now we have the full Supreme Court endorsing the approach that when it comes to the provisions of section 3317, the services have to be within the entitlement period. So if you get a worker coming along with, 6 weeks to go and they want a 3-month course of physiotherapy, you can approve the treatment, but only up until the end of the 12-month period. It doesn't extend the entitlement out past the end of the 12 months. So that approach was recently also confirmed in the case of Hewish, which basically followed on from Giammios. There has been another case about surgery, and is surgery in consequence of a work injury? Because of course, when you are looking at these issues about pre-approval of surgery and seeking more information, one of the things that you might be looking for is whether in fact the surgery that they're seeking is in fact reasonably necessary as a consequence of the work injury. And in the Marusic case, we had a situation, and it's a very common one for employers dealing with claims in this area, is the worker who suffered the aggravation of the underlying arthritic condition. So they've had their work injury, which has either aggravated or exacerbated the underlying condition. And then they come along because the doctor says, well, they need some form of surgery. And in Mr. Marusic's case, it was shoulder replacement surgery, had extensive underlying arthritis, but had also had 2 work injuries, one in February 2014 and one in the middle of 2016. The compensating authority was not prepared to give the approval because the worker suffered significant arthritis of the left shoulder joint. It was unusual for this particular worker because they were quite young. So the argument was, you know, what is the surgery relating to? Is it the arthritis or is it the aggravation? And we see plenty of those cases all the time. The tribunal found for the worker, surprise, surprise, and found that based on all of the evidence, the bringing forward of the need for surgery by reason of the work injury was consistent with the statutory test, and therefore the surgery was reasonably necessary. So they are, as always, still difficult arguments to maintain, even with the issues about significant contributing cause. So moving on to therapeutic appliances, one of the other issues that often arise under Section 33, and in fact in respect to the issue of time limits and the cessation of the medical expense time limit, that does not of course apply to a therapeutic appliance. We know from the case law now that hip and knee replacements are considered to be prosthetics and are therefore therapeutic appliances, as commented upon in the Ashfield case. So the 12-month time limit in Section 3320 doesn't apply to those procedures. So a worker could potentially come back a long time after the original work injury and say, well, now I need a knee replacement because of my work injuries, and I seek approval for that surgery to occur. And they don't necessarily have to have done the pre-approval application under Section 3321B2, which we're going to talk about now as well, in order to still be able to claim for that procedure. I mean, therapeutic appliances are not just hip and knee replacements. We're talking about things like orthotics, are clearly therapeutic appliances. Hearing aids are, you know, the bane of everyone's life at the moment with the number of hearing loss claims we're all getting, or most of my clients are getting. So they're all things that don't come within the time limit. So be mindful of what might be a therapeutic appliance. Okay, so the next section we're going to look at, which I just slightly talked about, is obviously Section 3321B2, which is the other provision which was initially confused with Section 3317. I'm sure you're all now well and truly aware of the provisions of the findings, in the Supreme Court in the cases of Ruddock and Kapithakis, that Section 3321B2 is different to Section 3317. So an application under Section 3321B2 will be an application made by a worker prior to the 12-month time limit expiring, saying to his employer that sometime in the future I may need future surgery, and I seek approval now to have that surgery in the future if I need it, such that I am not stymied by the 12-month entitlement period, and at a later date I can come back and have that surgery if and when I need it. Basically, as I'm sure all of you know now, the full Supreme Court in Ruddock and Kapithakis found that it was a different application to Section 3317, and a worker does not have to comply with the more stringent requirements of Section 33.18 and Regulation 22. It is a much more informal application and doesn't have to comply with that. Having said that, there has been further case law since Ruddock and Kapithakis, which relates to this issue, because I guess the problem that Ruddock and Kapithakis raise with the suggestion of it being a very informal process is that potentially any worker could come along, you know, with a month to go before the 12 months runs out and says, well, I think I might need surgery, so here's my email saying I might need it. I don't have any evidence for it, but I think I might need it, and therefore the time limit doesn't apply to me. The tribunal has frowned upon that approach, so it has been a little bit more stringent than that. So we have now the case of Soldi and Wesfarmers, where this issue as to what in fact does Section 3321B2 applications require in terms of how necessary is the surgery required to be, and what is in fact required to be submitted to a compensating authority, so that it can in fact determine the Section 3321B2 application. So in Soldi, basically the workers' union had put an email together. The evidence was not particularly convincing that the worker actually needed surgery or what that surgery might be in the future. The matter went to the tribunal and to the further up on appeal. Return to Work SA intervened in those appeals because it was a self-insured employer who ran the matter. And the tribunal found that the worker needed to provide some cogent evidence that was reliable and reasonable, that identified the nature of the surgery, provide information on the benefits that the worker would obtain from that surgery, information as to why the surgery shouldn't be undertaken within the medical expense entitlement period, and information as to the likelihood of the surgery being undertaken in the future. And the court said that the assessment of the request for surgery is a qualitative judgment in each case. So it's not a hard and fast rule necessarily, but clearly there has to be something more than, you know, an email or a half paragraph letter saying, well, I think I might need surgery in the future, but I'm not really sure what that might look like. So I think that, you know, basically the court's saying, well, there has to be something more than that. There has to be some reasonable medical evidence that supports that there is surgery potentially required in the future, and what that might be and why it isn't necessarily the case that the worker will have it now. I've done that. So in terms of practicalities, I guess the first thing when you're dealing with these applications is determine whether your application is one under Section 3317 or Section 3321B2. You can actually have a Section 3317 application that postdates a Section 3321B2. So the person who says, I need surgery in the future, and then, you know, 2 years later, they say, right, well, now I need the surgery. And in fact, they should then be required to submit a proper Section 3317 application with all the relevant evidence. So you can, in fact, make then a decision as to whether or not the surgery is, in fact, now required and is reasonably necessary. But leaving aside that issue, you have, you know, if you're dealing with something that's towards the end of the medical expense entitlement period, or just something during the normal life of the claim, you need to look at whether or not it's a 3317 application or a 3321B2 application, because that will have different requirements in terms of what the worker needs to do. And obviously, if you're satisfied that it's a Section 3317 application, the worker is going to have to provide a lot more information. Although now, following Soldi, there's certainly more work that a worker has to do if it's a Section 3321B2 application. as I've dealt with a lot of this, I'm just going to run through some of these slides pretty quickly. Once you get the application and you've determined what sort of application it is, then you know whether or not you've got a time limit, because of course there is no, in fact, set time limit for a Section 3321B2 application. And potentially with those applications, you could possibly just simply acknowledge receipt. And if surgery is not pending in the near future, you could advise a worker that you'll defer your decision-making process until such time as, in fact, surgery is required or pending. You don't necessarily want to have a big fight every time a worker sends you a request in this area, even though obviously SOLDI imposes more requirements upon them. There may be cases where it's just easier to defer the argument to, 2 or 3 or 4 years down the track, rather than having a fight now at the tribunal over it. So really that's probably something that you'll look at on a case-by-case basis and make a decision as to whether or not you want to be very strict on the matter, or whether you're simply prepared to allow the worker to come back, some years down the track and potentially have the fight at that stage, or the worker will hopefully then provide more convincing evidence. So the other topic we're going to talk about, and there has been now quite a lot of cases on this issue, Return to Work SA have run a number of cases about the issue of what constitutes surgery. And it is important because of the 3321B2 provisions, which allow a worker to, as I've said, apply for future surgery to occur. And the issue has been, well, what is in fact surgery within the meaning of the Act? And the reason is, not all of these requests are for people to have things like knee replacements and arthroscopy. A lot of treatments these days fall short of that, and people have steroid injections, nerve block procedures, Synvix, which is the it's that sort of plastic gel they inject into a knee joint to basically replace cartilage. So there's a whole heap of things that sort of don't fall within our understanding of what we perceive to be traditional surgery, where someone gets cut open and, either a part gets taken out or gets replaced. So this is, there've been a number of cases now on this issue because of this problem of, well, what does the Act mean when it's talking about future surgery? So we've had all of these run of cases. Dowden dealt with steroid injections, and it was found that a steroid injection in that case was surgery. McPhail, a nerve block procedure was considered not to be surgery, but I think that's been remitted back for some further evidence. Williams was the Synvix procedure, where that gel is injected into the knee joint. It was found to be surgery. And interestingly, they also ran an argument that that was a therapeutic appliance, but were unsuccessful on that argument, but it didn't matter in the end because it was still found to be a surgical procedure. And Curtis was facet joint rhizolysis, which was considered to be surgery. And for anyone who's looked at what that actually involves, it involves burning off the nerve ends in the joint. And that was considered to be surgery. But the case of McPhail is useful because the court did outline to a very large extent what it thought the indicia were for determining what is or is not a surgical procedure. So you'll see from the slide that it's a procedure performed by a surgeon or other medical specialist or practitioner with appropriate qualifications or special skills. That person is can be assisted by other medical professionals, including nursing staff. It's performed in an operating theatre or special environment. It's performed with anaesthesia, whether that's general, local, or an aspect of the procedure itself. Skill and precision is involved in the procedure, including whether the procedure is guided by aids or tools such as cameras or ultrasound. The procedure involves the penetration of the body by some means, and it's for the purpose of permanent or semi-permanent alteration or manipulation of the body. and the primary effect of the procedure is not necessarily temporary or transient alleviation of symptoms. So that's another area that the court will look at. This is not an exhaustive list, but it's a guide. So if someone comes along to you with a request for future surgery, and it may be one of these procedures, or maybe even a new procedure that the medical profession has started to use. As we know, medical science progresses all the time, and you're not sure whether it's surgery or not, then maybe go back to the indicators set out in McPhail and have a look at what is in fact involved. Now, that may obviously require going back to the doctor who's proposing the surgery or proposing the procedure, and getting more information from the doctor as to what it is in fact that they're proposing to do, and whether or not those indicators are in fact part of the process. The ultimate finding on appeal at McPhail was that a corticosteroid medication, which was designed to suppress the response of a nerve for a period of some months, was not surgery. So it did not aim to alter the pathology in any permanent or semi-permanent way. Dowden, the worker, was receiving epidural steroid injections into the spine. These were administered by a surgeon in a hospital, in an operating theatre, and under general anaesthetic. The judge thought that that meant this was in fact surgery, but that's been appealed. So this issue is still one that's ongoing. So I guess it's still a bit of a watch this space. So, we might still get some further case law on the issue, but certainly the indicators in McPhail are pretty useful in my view, particularly if you've got something unusual. So that's the end of my bit, and unless there's any questions, I'm going to hand back to Mel. I'm not sure how I would know if there's any questions, because again, I missed the practice, so somebody will tell me if there's any questions. Thanks for that, everyone.
Hi, so yeah, as Teresa said, that kind of concludes the stuff that we've prepared for you on the presentation aspect. So we'd like to open it up now if anyone does have any other questions. Please do send them through to us on that chat box. Bear with us, it might take us a minute or two to read them through. But we did have a question prepared a little bit earlier on. And,
Someone asked it.
Yeah, sorry, that's... yeah, so that someone has sent in and we've now prepared. So I'd like to invite Oliver to come up and speak to us on this topic.
Hi everyone. Yep, like Mel explained, one of the questions that did come through was in relation to the case of Morris and the Department for Child Protection. The question was, will the Morris case outcome enable employers to re-engage employees back into the workplace to perform suitable duties which match their capacity? Now, for those, you probably all are familiar with the Morris case. It was dealt with in two parts. So what we're going to do is I'm just going to summarise it first of all, and then kind of get into the answer. So the worker, Miss Morris, made an application seeking a review of determinations of her discontinuance based on alleged breaches of mutuality. Now, the worker was previously employed with the Department of Education. She was assaulted by a disgruntled parent over a child removal issue and sustained multiple injuries, as well as a PTSD order. She was assessed as having sustained 64% WPI, so quite significant. She received a significant lump sum under the old Act and was unable to work on account of her injuries, and then was therefore in receipt of weekly payments of income maintenance. The worker's claim then transitioned to the new Act, and as her WPI was over 30%, she was deemed a seriously injured worker and would continue to have a potential entitlement to her weekly payments until her retiring age. At the time of the decision as well, just for background, she was 50 years old. The issue in this case was whether her employer lawfully discontinued her weekly payments. So on the 1st of December 2017, the worker was found guilty of trafficking in methamphetamine and was ultimately remanded on bail pending sentence. Then on the 15th of January, the worker was again arrested for attempting to dissuade a witness from giving evidence, and she was brought before a magistrate who refused her bail for application. So not exactly employee of the month. She was then remanded in the Adelaide's Women's Prison. So the next day, the department suspended her receipt of her weekly payments in reliance upon Section 193 of the Act. Then the worker was terminated under the Public Sector Act for her misconduct. And then the department resolved to invoke Section 48 to discontinue the worker's weekly payments. So Section 48 allows a compensating authority to discontinue weekly payments in a few different ways. In this case, the worker is dismissed from employment for serious and willful misconduct. And when the worker breaches the obligation of mutuality. Then following on the 29th of August 2018, the worker was sentenced to a suspended sentence. And at the time of the first notice, the worker had an entitlement to weekly payments. What the judge said was, it is just that rightly or wrongly that entitlement was suspended on account of her incarceration. The judge said that in Morris 1, it would be surprising if Parliament intended that seriously injured workers could be freed of any obligation to work, and if that such workers could misbehave in the workplace with complete impunity in connection with their ongoing entitlements to weekly payments. In the first instance, the judgment is important in answering the question of itself as it deals with the mechanics of stopping the payments. So in Morris 1, the judge found that both determinations were lawfully issued and supported by the Acts. However, going back to the original question being, does it enable employers to re-engage the employees back into the workplace to perform suitable duties which match their capacity ties? Part 1 of the decision answers this really, where it says that all workers who are entitled to weekly payments and who have a work capacity, including seriously injured workers, have an obligation to perform suitable work on offer, to not unreasonably discontinue such work and to take reasonable steps to find it, such that in event of the breach of mutuality that potentially prevents that participation, they can be the subject of notice of discontinuance. So if a worker breaches mutuality under the current Act because they refuse to take up an offer of suitable duties, this would then entitle the compensating authority to discontinue the worker's weekly payments under, again, that Section 48. Kind of going further with the question, whether this leads into what if the worker is a seriously injured worker and has no capacity at all and on payments? Is the compensating authority at liberty to issue a Section 48 notice who do not have any capacity and on payments? This then goes into that second part of Morris, on Morris 2, that the more vexed question of the case is whether a breach of mutuality of this type can be relied upon by compensating authority in respect of a worker who has no capacity. If a worker has no current work capacity, committed acts that amount to breaches of the obligation of mutuality, whether in light of the lack of work capacity, the compensation authority can rely upon the breaches to effect a discontinuance of weekly payments. The notion of defeating a claim based on total incapacity is so integrally linked to the principle of breach of mutuality, it can only apply to a worker with some capacity, and therefore in Ms. Morris's case could not be relied upon. As the department conceded that the worker did not have any capacity at the time, it issued its discontinuance that were based on breaches of mutuality. That conduct did not comprise of conduct recognised as a breach of mutuality for the purposes of Section 48(3)(g). Because in connection with the provisions, the conduct must be conduct by a worker with some work capacity. Now, if you kind of bring both 1 and 2 together, if the worker is unable to perform any work as a result of the compensable injury, no issue of deemed total incapacity arises. Where partial incapacity is deemed to be total in the absence of suitable work being available. In other words, the concept of breach of mutuality as developed in the case law relating to the workers' compensation legislation has no implication in these circumstances. The question ultimately, though, does come down to the worker's capacity, and the employer can take the steps to re-engage the worker. If there is no capacity at all, you can take the steps to get them assessed and then have them re-engaged back into the workplace. If they refuse to comply, however, they could potentially be in a breach, and if it was found there was a complete incapacity, still though a discontinuance could not be made. But remember, there's some limits under section 25(2), 11, regarding the return to work plans. But realistically, it's easier said than done with this, to get a worker back to work who is totally incapacitated and won't play ball. You're unlikely really to convince us that a totally incapacitated worker can do the job unless they actually perform it. So it pretty much sums it up, in case any of the directors or Mel want to jump in.
Yes.
Thanks. So yeah, if any questions, back to Mel.
So at this stage, we haven't had any questions come through on the chat box. But again, we will proceed with one that we were presented with earlier, and I'd just like to hand over now to Susanna to run you through this one.
Hello everyone. So today I'm going to very briefly discuss whether an impairment should be disregarded versus should a portion of an impairment be deducted. I won't take up too much of your time, I promise. But in order for me to address this, we first need to turn to the mechanisms that are found in sections 22(8)(b) compared to section 22(8)(g) of the Return to Work Act. And then we can have a look at the case law, followed by a very brief example. So if we turn to section 22(8)(b), that section provides that impairments from unrelated injuries or causes are to be disregarded in making an assessment. Whereas section 22(8)(g) states that any portion of an impairment that is due to a previous injury, whether that previous injury is work-related or a pre-existing condition, cause the worker to suffer an impairment before the relevant work injury, it's to be deducted for the purposes of an assessment, subject to any provision to the contrary made by the impairment assessment guidelines. Now, creative arguments, let's just say, have been tested in recent times at the South Australian Employment Tribunal pertaining to impairments from pre-existing injuries under the Return to Work Act when are undergoing the PIA. But just because someone has had an injury previously or has suffered from a pre-existing condition, it doesn't guarantee that a deduction should be made. So let's turn to some cases, the first one being Frkic, or as majority of you would know it as Frick. So in 2016, the worker had sustained a fall and injured his back at work. The worker had a lifelong condition of ankylosing spondylitis, which in effect resulted in a fusion prior to the relevant work injury. Now, the worker solicitors argued that a deduction shouldn't be made because the pre-existing condition resulted in a fusion and the worker essentially lived lived actively and effectively prior to the relevant work injury. Whilst perhaps unfair to the worker, that is, a deduction was made on the basis that the worker suffered restriction of his posture and balance prior to the relevant work injury. And so basically what was held is that, well, this resulted in those restrictions being made worse by that fall. The decision has been upheld by the full bench, which consisted of Farrell, Kelly and Rossi this year. Let's have a look at the case of Mangano. This was a case that involved a worker who had pre-existing discogenic injury, which was sustained in 1998. In other words, he had existing impairments to the L5-S1 disc. The 1998 injury gave rise to only left-sided issues at the time, and the worker had a 10% impairment arising from this 1998 injury. Then in 2013, he sustained a work injury to the same disc, but this time giving rise to right-sided issues. So should a deduction have been made in this case? Well, it was held that no deduction was made. Whilst the impairment was to the same disc, to the same body part, the 2013 impairment was found that it was not causally related or due to the 1998 injury. So in other words, if we refer back to that mechanism under section 22(8)(g), it wasn't due to a previous injury, and the 1998 injury did not cause the worker to suffer an impairment before the 2013 injury arose. So you cannot use section 22(8)(b) to say that the previous impairment is to be disregarded altogether, but you cannot make a deduction either. We turn now to the case of Khan, that's Khan. This was a case where a worker had suffered a knee injury at work in 2009. So this is under the old Act, and it was due to a serious assault at work. Now, Dr. Dionise diagnosed the worker with a right knee osteoarthritis, an exacerbation of previous injury, whereas Dr. Biok diagnosed it as an aggravation of a pre-existing osteoarthritis. The worker received a lump sum payment in 2013 pursuant to section 43, because we are working with an injury that occurred under the old Act. About 5 weeks after a decision was made about him receiving the lump sum, he decided to undergo a total knee replacement. Following the TKR, of course, the worker wanted a top-up, essentially. His argument being that he had a higher rateable impairment now. Now, a creative argument was put by his solicitors that the arthritis was essentially removed by the TKR, and so a deduction shouldn't be made for the pre-existing osteoarthritis because there was no longer an impairment owing to it. Given that the deduction issue wasn't a central issue to the appeal, if it wasn't for other reasons, the full bench would have made a deduction because the worker's injury would not have occurred but for the pre-existing osteoarthritis, which was aggravated by his employment duties. So it was based on similar facts in the case of Nielsen. The last case that I'll briefly mention is the case of Belperio. This concerns an upper back injury. Now, during the worker's treatment, it was discovered that the worker had a pre-existing fusion of discs in his upper back. The worker's spine was found to be more vulnerable to flare-up due to the pre-existing fusion, and so therefore it was held that a 20% deduction was to be made. Now, no discretion to ignore the fusion to arrive at a fair result was considered. So it is not a matter of just saying, for example, well, Ben, who suffered a compensable left knee injury in March 2019, had a pre-existing injury as referred to by his GP in a consultation note dated XY 2009 when his brother kicked him in the left knee, and therefore a deduction should be made. No, a mere complaint or to the GP or even a diagnosis perhaps in a report by that GP doesn't provide sufficient evidence that he suffered a level of impairment prior to the relevant work injury. If, however, there is radiology or pathology to suggest that Ben had bone-on-bone friction, for instance, then arguably there is sufficient evidence for a deduction to be made. So, in conclusion, you must be able to point to more than the mere occurrence of a past injury. It needs to be a substantive condition capable of being assessed of itself as a particular form of injury to be disregarded, or an assessable impairment of itself to be deducted. If there are any questions, please type them up in the chat box. Otherwise, I will hand back to Mel. Oh, sorry, I think Mark has something to add. No, never mind.
Thank you. So following on in a similar vein to what Susanna has discussed, one of the questions that I've also been put is actually in regards to the permanent impairment assessment reports, and there had been a kind of a bit of a topical issue that there was concerns raised that process wasn't particularly impartial, where the permanent impairment assessors had maybe been put under some pressure by return to work to alter their opinions and things. So these issues had been raised in some recent tribunal decisions. I think I'm going to employ Susanna to say the case name for me because she said it so eloquently. But I'm going to say Vrkic. There we go. And the return to work. So then there was Palios return to work and the Canales Cordova return to work. So in these decisions, then the tribunal actually set out in some detail what they thought would be the inappropriateness of that one-sided unilateral communication between return to work and that practitioner. So where that communication was, in their view, was expressed to alter their assessment. So that they thought that some unilateral communication that seeks to coerce or guide them to change their opinion is actually not permitted. So the full bench's decision in the Vrkic, I'm going to try, case states that they actually agreed with the reasons in the case of Palios and the Canales Cordova, that the unauthorised and inappropriate or unlawful actions by the respondent in trying to look to alter the permanent impairment report may actually result in those subsequent reports provided actually being excluded. So Return to Work did provide a response to this and had kind of, clarified that as part of that compliance review process, that sometimes they may need to seek clarification from assessors to ensure that those permanent impairment reports actually are in accordance with the IAG, the impairment assessment guidelines. So it would be only really in that context that if there was non-compliance, that they would be going back to that assessor to have that report, somewhat corrected. Because it is actually stipulated in the Act, and this is the reason why they'd be going back to the assessor, that those reports must be in accordance with the guidelines, and those guidelines then are based on that AMA 5. So which kind of dives into the next kind of part that I was going to discuss with you, which is the construction of the AMA 5 is of utmost importance, and this has actually also been addressed in a recent case of Dallimore, which looked at the construction for the purpose of a permanent impairment in regards to, which is quite a tricky area, of a pulmonary embolism and hypertension. So in this case, the worker was injured and he fell and actually fractured his leg. But then following that surgery, it was that he developed the deep vein thrombosis, and then that led to the pulmonary embolism with some lung infarctions and some hypertension. So under that, the worker brought a claim obviously for compensation, and part of that process, this matter progressed to the tribunal, and then there was an assessment of permanent impairment. And so in that process, the state decided there was an assessment of 29% whole person impairment, which was actually related to that pulmonary hypertension. So as you can understand, given that that was quite a high WPI, the decision had actually been appealed and now cross-appealed to the full bench. So then when the full bench examined this issue, they had a look at, well, they thought that their applicant then, or the worker, sorry, he didn't actually have a rateable impairment for that pulmonary hypertension. And so this then turns on that construction of the AMA5. So on this, there was a further appeal. So in that, it was considered whether, is this a valid ground of appeal, the construction of the AMA5. And so ultimately the Supreme Court said they did grant that leave to appeal because obviously it was of significant importance to the worker and importance more generally in terms of the construction. So it was submitted to that full bench that they had then looked and kind of confused and conflated the diagnosis of the pulmonary hypertension and that assessment of permanent impairment, and then therefore they'd misconstrued and misapplied AMA5, and then in concluding that they had that he had that 0 impairment for the hypertension or no assessable impairment for the pulmonary hypertension. So at this stage, that matter is still under appeal, and we'll have to wait and see what happens with the case. But I guess what this kind of issue and this topic highlights is that if you are of the view that there is an issue with compliance of a permanent impairment report, it's probably worthwhile considering getting a report independently peer reviewed by somebody to make sure that it's in accordance with the IAG. And then the case law definitely is in support that only the matter of form, and so that's technical compliance with the guidelines and AMA5, not matters of substance, for example, the medical opinion on which it's formed, can be challenged or reviewed. So for example, had they used the wrong table, had they added 2 and 2 and they somehow got to 10, that they're the kind of things that you should be looking out for. And so then in the context of a dispute, we understand that as it stands at the moment, the tribunal will permit some kind of contact where it's in the context of a dispute, but only also with the consent of the parties. And it is also worthwhile noting that at this stage, the tribunal is not so favourable on the sending of any kind of video evidence to discredit, I would guess it is maybe to highlight some of the discrepancies maybe in the presentation of the worker, sending that to the assessor as part of the process. So that might be something that you need to leave up your sleeve for a matter at trial. So at this stage, I'm just having a quick look there at the chat box. Don't think anyone sent anything through. So I'd like to hand back to Mark to wrap up today's session.
Thank you, Mel. Thank you, Susanna, Ollie, Neville and Tracy for your assistance in presenting this afternoon's seminar. This has been a first for us, so we'd love to have your feedback and we'll be sending out that information package in the next couple of days. So feedback about the webinar, how you thought that went, how you think we're going. Hopefully we've supported you through COVID-19. It's been a difficult year. We'd love to be able to have a Christmas drink with you, which is what the intention of today was, were it not for COVID and restrictions, etc. So look, if we don't get a chance to meet some of you at CISA next week, we hope you have a wonderful Christmas. Thank you for tuning in this afternoon. If you were riveted to what we talked about and want to look at it all again, then we will be able to hopefully notify you fairly soon that we'll be putting this up on our website or sending you a link to a recording of this. So look forward to that. We look forward to seeing you in 2021. Otherwise, have a tremendous break, and it is now officially
Beer o'clock.
beer o'clock or sparkling wine o'clock.
Yeah.
Okay. See you all. Bye.
Yeah.
Bye-bye.
Was there a door up there? That's what I'd like.
Yeah.